Hi, this is Kyra, and I wanted to do a video for you to tell you what to expect at your mediation. You might have been notified by our office that you have been selected for mediation, and you may have some questions about what it means to go to mediation and what you need to do to prepare for mediation. And so I wanted to just kind of sit back and give you just my kind of take on what's about to happen, why you should be excited about going to mediation, and what you can expect from the process. And so one thing that you should know is that mediation almost always is voluntary. There will be some times when the judge will order us to go to mediation, but that does not mean that you have to settle your case at mediation. Now, there are some really good reasons why you should settle at mediation, but it is not something where there is anyone who's going to tell you, you have to settle your case today. And certainly no one in our office will tell you that you have to settle your case today, because that's just not how we operate. But so let's first talk about what mediation is. Mediation is a meeting that you go to with your counsel and with the other side and a neutral, a person who's usually a lawyer, sometimes a former judge, who will go back between you and the other side to try to get to a resolution of your case. Now, obviously, when you file a lawsuit, there is always a possibility that your case will go to trial. But there are a number of times around during the pendency of your case where you might get your case dismissed, or there may be some things that happen for the other side that make them think their case needs to be settled. But there is never a guarantee whenever you get into litigation, whether you're on the plaintiff side or the defendant side, that the litigation will go the way that you think it will. Everyone wants, there can only be one winner in litigation. And so, there's always a significant chance that you will lose your case. So mediation is an opportunity for each side to kind of go and talk about the strengths and the weaknesses of their cases so that they can come to a resolution that, while it may not make everybody exactly happy, or you won't leave a mediation feeling like you stole a bag of money, but you will feel like you have resolution, and hopefully you can come to an agreement that is fair. And fair does not necessarily mean getting everything you want. Doesn't mean that the other side believes in the strength of your case. It just means that the two sides have come to an agreement about a way to end the fight. Okay. And there's a lot of reasons why you might want to end a fight, right? You could win the fight and you could get everything that you want. That's one option if you continue going on with your case. But you can also lose your fight and you can get nothing. And so going to mediation is sort of an opportunity for you to figure out a way to settle your case that limits your risk, but also does compensate you in some way for the loss that you've suffered. Okay, so the mediator in a case is usually either an experienced lawyer, or sometimes it's a former judge. And that person is there to kind of help people see the other side's point of view. Okay, and you're not going to want to hear that, right? When the mediator comes into your room, generally they come to the plaintiff first. They're going to listen to your story, and they're going to talk to you about the things that you think are the reasons why you should get paid and the reasons why they have done something wrong. And then they're going to take that information and go to the other side. And during their conversation with the other side, they're going to listen to what that person believes, the defendant believes, are the strengths of their case and why they should win, and what the weaknesses of your case are and why you should lose. And then that person's going to go back to the plaintiff, which would normally, in our case, be our client, and say, okay, now I know you told me about this fact and that fact that you think means that you should win, but what do you think about this fact that they told me about their case? How do you think that affects what you think? Okay. And do you think they maybe have a point about this thing? And so The reality is that in most cases, there are a few cases that go out there where liability is absolutely clear. There's no question one way or the other that something happened and who was at fault. But the vast majority of cases have some little bit of gray area. Maybe some of the facts are not in dispute, but your damages aren't as high as you think they should be, or they think they should be. Or maybe they have a witness who contradicts some of the things that you say in your statements. And so while you may get to a trial, the jury could believe differently. Or maybe there's people who, while you think it's really important what happened to you, may not value the cost of that harm the same way you do. And so the mediator is going to come and share their wisdom and their experiences with you so that you can help evaluate the way this case might look from an outsider's perspective, so you can get a better perspective on whether you have some things you might want to settle for. Okay? Now you're going to go back and you're going to hear all that stuff, and it's probably going to make you angry. You're like, what? I can't believe that this person is saying they don't owe me this money. I don't want you to take that to heart. It is the lawyer's job on the other side to advocate for their client, and nothing that they do requires them to believe everything that you say in the way that you presented it. There's just not a requirement that they ever come to an agreement that you were wronged. That's not something that we're ever going to be able to get out of litigation. It's very rare. So the fact that they shared their side does not mean that they don't think that there is some value in settling your case. It just means that their valuation of the case may be somewhat different than your valuation of the case. And so the goal for the rest of the day, once each side has heard the other side's point of view, is to kind of figure out if you guys can move closer together and settle the case. Okay, now what does that require of you? You've got to be open-minded, right? You can't go into a negotiation of any time thinking, I will not move. I cannot move. If you have only $1 that, $1 figure that you will take and nothing else matters, we don't need to be in mediation, and you need to have a trial. Now, if there is some room for you to negotiate, or some things that you might be able to accept that are non-monetary, that are of value to you, then there's some room for you to negotiate. By the same token, if the other side comes to mediation and they don't have any money in their pocket to pay you, or they're just wasting your time, well, we need to figure that out, and we need to leave as well. So both sides have a duty, if we're going to have a mediation, to try to get everyone on board and do their best to settle the case. All right, so they're going to tell you their side, and they're going to give you an offer, and then you're going to have to respond. And generally in our mediations, I like to have a conversation with my client first, and then I'm going to kind of lead the way during the litigation and also the negotiation. So we will have talked before the case got to mediation, and we'll talk about like what I think the value of your case is based on my experience, what they think are the strengths and weaknesses of the case, and we'll come to a figure that is your authority. And then during the negotiation, I will throw out counter offers without asking you. Okay. Now, if ever there's a point where you really, really disagree with the counter offer, if it's way under what you thought you would want to accept, we should have already dealt with that before we got to the mediation, right? Because we should have had a conversation about what your bottom line number is. And then you're going to give me permission to kind of make moves above your bottom line so that we can get more than what you're expecting if we can. And if not, to get as high and as close to the number that you want so that we can get you the best resolution possible. Now, as we go back and forth, it's going to seem insulting. So they won't pay you this. We're talking about this number up here, and they're talking about a number down low. And it's just insulting that they won't just immediately come to an agreement that says, I'm going to pay this person what this person believes is fair. Mediations can sometimes take a very long time. just as emotional, and is just as emotional as it is for you, it is for the defendant. And it's hard for you to realize that because it's affected your life, right? They may have done things that have caused you great emotional as well as financial strain. At the same time, people do not like having to focus on the fact that they may have harmed somebody, or they may have problems paying what may be due to another person. And so they may be negotiating out of a place of, hey, I don't have the money to pay this person. And so you have to be thinking as the plaintiff that there's a whole host of things going on in their heads that are just as emotional as the things going on in your head. And you have to be willing to understand that in order to come to a resolution. So let's say you do come to an agreement with the other side about how to settle. Well, after that, the mediator is going to come to the parties and probably have sort of a brief written agreement that says the major term. And in our case, generally, the major term is the amount of money that will be paid and the time frame in which it will be paid. Okay. Now, after that, we'll sign that agreement and each side will go back to their respective offices. And the defense lawyer is probably going to ask us to sign a second agreement. And that second agreement is going to have a lot more terms in it. It's going to be more inclusive of some of the things that normally would go to any standard settlement agreement. So just because you settle your case today does not mean all the paperwork is done. Okay, so normally 2 to 3 weeks after that, we're going to get an agreement from the other side that we need to review and look at. And then after that, you will sign it. And then after that, you will get paid. It is important that you do not expect that you will get any money the day that you settle your case in a mediation. Always give yourself 4 to 6 weeks after settlement, after the date that you agree to the amount for you to get paid. If you can't get to that 4 to 6 weeks, it's going to be really, really difficult for people to cut checks. And so there's a lot that goes on. The lawyers have to negotiate some of the terms of the settlement. We review it, send it back. We talk to you about it to get you to sign it. And then they have to process checks, which involves getting your tax information, getting our law firm's tax information, sending that off to the side to their accounts payable and getting things done. So it's often not an immediate process, and you cannot expect that you will be paid immediately. Okay. So once you've had that, then your mediation, once the checks are paid to you, which is usually 4 to 6 weeks after you settle the case, once those checks are paid, then I will and the other lawyer will go and file a document with the court dismissing your case. And that will say that the parties have resolved the case and all will be over. But generally, from the time that we agree to go to mediation to the time that it's over, could be 2.5 to 3 months. So just understand that it's a process, and the date of your mediation is not the date that everything ends. Now, what would you need to do to get prepared? Well, we need to make sure we have every document that is relevant to your damages. So if you're claiming that you have lost work, then we need to see the evidence of your lost work. Or if you've gotten a new job and so you're not making as much, we need to see the evidence that you are not making as much as you were at your former job. If you have other damages like mental anguish damages, those are damages that we usually like to see some documentary evidence for so that we can push that to the other side. So if we have medical records that show that you've sought psychiatric counseling, or health records that show that your blood pressure was elevated after the event, more so than it was before the event, those are documents that we will want to give to the other side. And we may want to reference those in mediation to help them give the best information to the people who are making the decisions to cut checks. Okay. So holding information back at a mediation is never a good idea. Now, ideally, if we're going to mediation, you've already given me this evidence that I need to help explain to them why they should pay you the money that you are owed. And so it's important, if you find that there are some other information that you think that you want me to throw in, hopefully you've given it to me before so I can evaluate that and pass it on to the other side. Okay. So that's what's going to happen at a mediation. A lot of our cases do go to mediation, probably not all of them, but maybe I'd say 10 to 15% of our cases do get mediated. It's something that we do pretty frequently. Sometimes we do them at the EEOC before litigation starts, and sometimes we do them at the very end of mediation, once we all know a lot more about the case. So if you have any questions about mediation, we will send you some emails and some information about what your mediation will be like, and for you to get prepared. But if you want to contact us and you have some specific questions, you can always email Fontenot at 5pointslaw.com so that you can get that information.